Welcome back, law students, to another explainer. All right, let's jump right in, because today we are tackling what I like to call the ultimate judge's dilemma. We're looking at that fundamental tension between enforcing the strict, literal letter of the law and, well, ensuring actual justice. If you've ever sat in class and wondered where a judge's power truly ends and a politician's begins, this is literally the boundary line we're exploring today. So grab your notes, because this is going to be absolutely crucial for your exam prep.
Okay, here's our roadmap for today. We've got 6 quick stops. First, the separation of powers. Number 2, science versus the spirit. 3, testing the literal rule. 4, DNA and absurd results. 5, judges as legislators. And finally, number 6, guardrails against overreach. Let's get right to it.
Starting off with Section 1, the separation of powers.
Now, you know this is the basic cornerstone of administrative law, but it brings us right to a massive, really Socratic question. Does interpretation by judges actually move into the realm of lawmaking? Think about it. When a judge interprets a statute, are they just reading the words on the page, or are they crossing a line and quietly legislating from the bench? I want you to keep that specific question in the back of your mind as we unpack how judges actually read the law. Moving on to Section 2, science versus the spirit.
This right here brings us to the core dichotomy of our whole explainer. Notice how these two words that even seasoned lawyers kind of use interchangeably, are actually entirely distinct legal concepts. We're talking about interpretation versus construction. Interpretation is called the science of sense. It gets triggered when the language of the law is plain. It's totally unambiguous. In this scenario, the judge is strictly restricted to the black-letter law. They're literally acting as a mere mouthpiece for the exact idea the legislature wanted to convey. But look at the other side. Construction. This is the art of spirit. This kicks in when things get messy, when there's ambiguity, inconsistency, or just flat-out absurdity in the text. Construction allows the court to draw conclusions that lie way beyond the direct expression of the text. It's about reaching for the true spirit of the enactment when the literal words just fail to cover unforeseen situations.
Which brings us to Section 3, testing the literal rule.
So let's look at how these theories actually play out in landmark case law. The absolutely crucial point here is establishing our baseline, and for that, we look back to the 1955 case of Judicial versus Raw Cotton Co. This case laid down a very clear marker. Literal interpretation is the cardinal rule. It is mandatory. The judge absolutely must act as that mouthpiece for the text, right up until doing so creates a manifest absurdity.
Now, let's test that mandatory literal rule with some pretty wild facts from the 1844 Sussex peerage case. Picture this. The petitioner, Sir Augustus, was born in London. His dad, who happened to be a duke, had gotten married without the consent of the king. Now, that consent was explicitly required by the Royal Marriage Act. So, to try and cleverly bypass this law, the duke traveled all the way to Rome to have the marriage take place there. Well, after the duke dies, his son applies for the continuation of the peerage. But suddenly, the validity of that Roman marriage is called into question under the strict, literal text of the Royal Marriage Act. So what happened? The court applied the literal meaning and completely shut down the loophole. They ruled that the act clearly stated that no marriage by direct descendants of King George could happen without the sovereign's permission. Through literal interpretation, this created a personal incapacity for the duke. And here's the real kicker. That personal incapacity applied no matter where on earth he got married. Rome, London, it literally didn't matter. Any matrimony without consent was void and null for all intents and purposes. So the son, he could not inherit the peerage.
All right, on to Section 4, DNA and absurd results.
Okay, so what happens when modern biology violently collides with strict legal fiction? Let's look at how this plays out across this really fascinating timeline of cases dealing with paternity evidence. Look at 2001. In the Comte-Davey case, the court stuck to a strict, literal interpretation of the Indian Evidence Act. They held that birth during a valid marriage was conclusive proof of legitimacy, period. It absolutely could not be rebutted, not even by modern DNA. Fast forward to 2014 in the Nandalal case, and we see a massive shift into the art of spirit. The court finally recognized that when there's a conflict between the legal fiction of conclusive proof and the cold biological truth of a DNA test, well, sticking to the literal rule produces a manifest absurdity. So they broke the literal rule in the true spirit of justice. And finally, adding some much-needed nuance to this power, we have the 2026 Nikhat Parveen judgment. This observed that a DNA test must not be ordered in a mechanical manner. This ensures judges don't just blindly rely on science without exercising real judicial prudence. Coming right out of that evolution, we get the modern two-step rule for DNA replication. You are definitely going to want to lock this in for finals. Step 1. No DNA is permitted if there is no prima facie case of non-access between the parties. But step 2, once DNA is made a part of the court record, you simply cannot ignore it. The biological truth officially overrides the legal fiction once it's validly introduced.
Next up, Section 5. Judges as legislators?
So if courts have this flexibility to break the literal rule for the spirit of justice, you might be wondering, does this mean they're secretly acting as politicians? Well, Justice Holmes gives us a brilliant framework to illustrate the difference. Look at how he defines the scope of power here. He noted that judges are confined to what he called molecular motions. These are small, very case-specific adjustments. They're basically just tweaking the tiny molecules of the law to fit specific unforeseen facts. Legislators, on the other hand, are focused on molar motions. That means massive, broad, general lawmaking that shapes society at large.
Building on that idea, Justice Cardozo famously argued that, yes, judges do legislate, but they only do it interstitially, meaning they only legislate in the tiny gaps between the existing laws. And to stop them from just applying their own personal whims, judges rely on what he called a judicial subconscious. This subconscious is highly trained to seek out and reflect the actual standards of life in the community, kind of like a legislator does, but strictly confined within those tiny molecular gaps of the text.
Which takes us to our final section, Section 6, Guardrails against judicial overreach.
Because we clearly need strict limits on this interstitial power, right? Let's dive into the specific case laws that act as our guardrails. These are the hard precedents that actually stop courts from going too far and crossing over into the legislature's territory.
First up, we have the 1992 case of Union of India versus Diokinandan Agarwal. This case firmly held that judges simply cannot legislate and must never usurp legislative functions. But it's the 2007 DMR Valley Golf Club case where the Supreme Court really laid down the hammer, and honestly, with a little bit of humor. The court warned that judges must not behave like emperors. They can't just run around creating new administrative posts just because they think it's a good idea. The specific example they gave? A judge cannot magically convert a gardener's post into a tractor driver's post. That is an administrative, executive function, not a judicial one. No way around it.
And that brings us to this absolutely definitive quote from the 1998 Supreme Court Bar Association versus Union of India case. It perfectly defines the ultimate boundary. Under Article 142, the Supreme Court has a curative power to deliver complete justice. However, the court ruled that this power can only supplement the law. It can absolutely never be used to supplant or ignore substantive statutory rights. In simple terms, you can fill the gaps for sure, but you cannot bulldoze the statute itself.
Which leaves us with this final, somewhat provocative thought to ponder as you guys prep for your exams. If Article 142 allows courts the curative power to deliver justice by supplementing the law through the art of spirit, just how close are we on a daily basis to actually supplanting it? Where exactly does the molecule end and the molar begin? Keep that delicate balance in mind, and you will absolutely ace your administrative law questions. Thanks for joining us for this explainer, and keep studying hard.